Hello and welcome back to Marketing Management and Brand Identity in the Music Industry. This week we're going to be talking about copyright basics, the history of copyright, and what the heck is registration and registering yourself as an artist. Yeah. Okay, let's begin. Just as always, folks, you can find this slide presentation on our Google Classroom if you wish to go at it at a slower pace or at your own pace, rather than listen to this video. All right, let's begin. So remember from last week, we talked about advances, and actually the week before. No, last week, sorry, was all about advances. So you want to get as much as you can up front. That's really important. And sorry, last week we talked about 360-degree deals. 2 weeks ago was advances. This past week was 360-degree deals, or the all-in deals. Okay, remember, record companies, okay, they now continue to participate in the entire circle of income of the artists themselves, okay? They reap the benefits, both the artist and the record label, the record company, reap the benefits of the artist's recordings, the merchandise, the sponsorship, any endorsement that the artist might have, as well as any income made from live performances. So, copyright basics. Well, the copyright is the most valuable asset, the most valuable thing in the music industry, because it gives the author of the work a monopoly on those works for a certain period of time. So they actually make money on those works over a certain period of time, very similar to a patent. So the history of copyright. Well, in Canada, the first Copyright Act came into place in 1832 from the British Parliament. Okay. There are four primary income generating rights that we're going to talk about: the mechanical rights, the public performance rights, the synchronization rights, and the derivative rights. Now, we're going to get into way more detail of those four income generating rights next week. But for this week, it's just a general overview of the history of copyright and what registration is all about. We're going to talk about in the next couple of weeks how to register. That would be today. Okay, next week we're going to talk about infringement, copyright enforcement, and what the heck is fair use, okay, which is a defense for copyright infringement, okay. So, the importance of copyright. I really like this photo on the right here, McDonald's and Nike, and you got the NBA symbol and everything on these, and Nike is spelled wrong, but they can get away with it because it is spelled wrong. Same with McDonald's. It doesn't quite infringe upon copyright. It's still, the logos do, but the words do not. So it's interesting. All right, so the importance of copyright. Well, copyright and the composition, so your actual written piece of music, is a very important asset to the music industry. Lionel Richie, okay, he claims that in the 1980s, he used to ride around Los Angeles with a tape recorder, and he used to record songs that he heard in his mind, just in case somebody else, for some reason, was able to pick up the copyright on those recorded tunes. But he recorded them as soon as he had them to protect himself, so he had some proof of that music. So Canadian copyright law protects creative works of the mind, so the intellectual property, for a limited time that are established by the House of Commons and the Parliament of Canada. There are these are different than real estate properties, okay? So remember, real estate, like houses, okay, you own that real estate in perpetuity, which means you own that piece of property forever. Whereas the intellectual rights, so copyright in terms of your musical performance, or even a book that you might write, okay, you have the copyright rights for a certain period of time, not in perpetuity, not forever. No one can use the works during the term of the copyright without getting your or the author's permission. So, history of copyright here. For the first Canadian colonial copyright statutes, the first law, like I said, was the Copyright Act in 1832. It was very short, and it declared ambitions to encourage the emergence of literary and artistic people to write, to publish, and to get their artistic works out there. Now, the term for this copyright was only 14 years, and after that 14 years, anybody could use it without any penalties. In 1841, so about 10 years later, Copyright was only granted to people who published books, maps, charts, musical compositions, prints, cuts, as well as engravings. In Canada's Confederation in 1868, the Parliament of Canada passed the new Act, Copyright Act, which granted protection for any person who is a resident in Canada or any person being a British subject and resident in Great Britain or Ireland. And that still included everything that was labeled in 1841. An amendment came around in 1921 to the Copyright Act, which gave the terms of copyright in Canada to 50 years after the creator's death. So, for example, if, let's say, I wrote a piece of music today and I published it and recorded it and got it out there, and let's say, for whatever reason, I get hit by a car tomorrow. Okay, 50 years from tomorrow, that copyright then would go into the public domain for anybody to use. But not until 50 years after my death, not until 2070 will that be people allowed to use it without penalty. Okay, sound recordings were also protected as musical and dramatic works. Okay, the rights were conferred in 2017. Copyright, okay, it includes the first right to first publish, reproduce, perform, transmit, and show a public work, so live performance. That is Copyright Acts. There's moral rights, which allows the author of a work to determine how it is being used and what it is being associated to. So, for example, if a piece of music that I write goes towards the recording in a movie, and I don't want that to happen, that would fall under moral rights. And then we get neighboring rights, okay, which is discussed primarily in the music industry. For example, the performer's rights and the recording rights all fall under the neighboring rights section. So, what is public domain? Well, remember, they've changed the term of copyright. So, previous, it was in 1921, remember, it was 50 years after the author's death. Now it is 70 years after the author's death before it goes into what is called the public domain. And the public domain is where anyone in the public can then use that work without getting the permission of the original copyright owner or, quite frankly, anyone else. There are a few songs out there that are part of this. Okay. We also get this term work for hire. Okay. If you are signing a contract with a label or corporation that is work for hire, corporations then own the works that you create. Okay. They do pay you quite well. And those rights are actually extended for 95 years after the author's death, if it is a work for hire type of work. If you have more than one author of a work, okay, the 70-year period doesn't start until the death of the last survivor. So, for example, author number 1 died in 2006. If the second author, he survives to 2035, okay, that 70-year period starts when the second author passes away, which means that the piece of work or the piece of music would go into the public domain in 2105. That is when the copyright is up and it goes into the public domain. Remember, copyright laws differ from country to country. From Canada to even the United States, there are quite a bit of difference in terms of how you go about getting a copyright and protecting yourself. It's quite a process in the United States. You have to register with a whole bunch of different organizations in order to protect yourself. Okay, so the performing arts rights and registration. These are kind of we're going to talk about two things here to wrap up this presentation that are really, really important. So performing arts rights and the registration of your pieces of music or your recordings, okay, protects the music composition and the lyrics, and it's actually the proof of ownership. Okay, these are songs that are owned by the songwriter and the publisher. Copyright, just so you're aware, in Canada is automatically acquired from the moment you write that first note of your song, okay, provided that you meet these three criteria. The work must be original, Okay, so you cannot take any ideas from anybody else. It must be fixed in a somewhat permanent material, for example, a sheet music or recording. And the author must meet the qualified person requirements set in the Copyright Act of Canada. That simply means that you must be a Canadian citizen for copyright to apply to you in this country. Okay, there is no requirement that you register one's copyright in order to acquire a copyright. You don't have to register with a government or an agency. It is good to do so, okay, because this then gives you proof of ownership, that someone says, someone validates what you've created as is to be yours. But remember, the moment you put pencil to paper or that you start a recording, okay, that copyright is yours forever. And 70 years past your death, which won't be for a long time. The other type of recording is called their sound recording rights. So we've got the performing arts rights, and now we have sound recording rights. So sound recording rights protect the fixation of sounds that make up a recording of a composition. And it actually prevents someone from duplicating your piece of music or even chunks of your piece of music. Also, sound recording rights enable you to protect any artwork that maybe you have drawn on your CD or album cover. Okay, in Canada, you can protect both the composition and the sound recording on the same registration form if you wish to register it. In the United States, artists have to go to two separate organizations to protect both the composition and the sound recording. But in Canada, you can do it together, which makes a lot more sense to me. Now, copyright in a performer's performance. So let's say you're performing on stage or somewhere in public. Okay, in a sound recording, and in the sound recording itself, that lasts for the remainder of the calendar year. Okay, so let's say someone records you at a live concert outside on their phone. They record you. Okay, and let's say they want to publish that and make money off of it. So, for example, they publish it to YouTube and they're making some kind of, advertisement fee back on that. Okay, they can't do that for 1 calendar year. Okay, they cannot make money for the remainder, of the calendar year, during which the performer's performance and sound recording, okay, respectively first occurred. So 1 year from that live performance. Now, I've just given you, some really useful resources to give you a little bit more information on what copyright is in Canada and how to protect yourself. Okay, these are just some organizations that you can register with, or that you can actually take a look at, that really lay out the Copyright Act in Canada a little more solidly. And in more detail. Sorry, my allergies are killing me today. Okay, we've got the Songwriters Association of Canada. We've got the Government of Canada, which lays out the Copyright Act. We have the Canadian Intellectual Property Office. The Canadian Song Vault, which used to be called the Canadian Song Depository. The Canadian Music Reproduction Rights Agency Limited. They are really good at helping artists in terms of copyright and protecting themselves, as well as the Society of Composers, Authors, and Music Publishers of Canada, SOCAN. That's everything for today, folks. Thank you very much for listening. As always, if you have any questions, please feel free to email me at any time, and don't forget to answer this week's discussion question. All right, bye for now.